Wouldn't want it any other way.
So hello and welcome to today's Info2Go webinar. My name is Annie Gaines and I am the Continuing Education Consultant here at the Idaho Commission for Libraries, located in sunny Boise, Idaho. Our webinars and other continuing education opportunities are funded by the Institute of Museum and Library Services. Everyone is muted and we encourage you to use the chat feature to ask questions and discuss with other attendees. As you exit the webinar, you will be prompted to complete an evaluation, and we always appreciate your honest feedback. Today's topic is public records requests, presented from Jim McNall from ICRMP, Idaho County's Risk Management Program. Jim, thank you so much for being here today.
Thank you. It's great to be here.
Did you want to go ahead and share your slides?
Yes. Sure. There we go. Okay. Oh, this one is already up. Okay. All right, now we're going.
Yes.
So, thank you, Annie, for that introduction. So a little bit about, oops, we're stuck. There we go. Okay, a little bit about what an ICRMP is. As Annie indicated, it's Idaho County's Risk Management Program. We are a risk pool for local governments. So we provide property and liability coverage, and then we also provide a variety of assistance to help our members not use the insurance we provide for them. So most of the libraries in the state are probably going to be covered one way or another, whether you're a library district. Most public libraries connected to cities. Most of the school districts are our members. So and all of the community colleges. So we don't cover the state, we don't cover the larger universities, but other than that, most public agencies, not all, but most are our members. So let's get on to talking about public records. Believe it or not, the Idaho statutes aren't really up to date in terms of dealing very well with the way we communicate today. So there's always a lag time. So there's conflict sometimes between the way the statutes read and dealing with records such as documents stored in the cloud, voicemail messages, social media, personal blogs. As long as they're personal, they're not public records. If they deal with your agency work, then they are. Just in the for what it's worth category, many of our members are now posting more and more information about them, such as meeting minutes, budget information, other types of things that they're posting them on their website to lessen the number of public records requests, because if someone wants data of some kind, you can just say, go to our website, it resides there. And that's a good way to make those conversations short and more responsive to the public's needs and wants. So we're mostly going to talk about the role of the custodians, but I want to start off with talking about the role of the governing board. The governing board in this case would be whoever your elected officials are, or appointed in the case of a public library. So the board needs to designate a custodian or custodians, ideally more than one. So for most libraries, it's probably going to be the library director, unless you're a very large library, and probably one or two others. The goal is to make it so that if one person's out and you get a public records request, you can still respond to that. Second role for the governing board is to establish a fee schedule. Some of you have had this experience, and more of our members are running into times when we have extremely large public records requests. I know some of our smaller members have had public records requests that read something like this: I'd like a copy of every document you have or have ever had. Well, that's probably not something you want to do without a little bit of remuneration to help cover those costs. So the statute provides that the first 100 pages or 2 hours are free. Beyond that, your agency can establish a fee. And we'll talk about that a little bit later. The third one is probably the most important. anyone who's a custodian of records needs to have ready and immediate access to legal counsel for the agency, because we'll talk about that. This will be a recurring theme. The way to stay out of trouble with public records requests is to consult with your attorney and follow their advice. Then the fourth thing, which kind of doesn't deal with public records requests, but it can sometimes, and that is every agency for a number of years has been required by statute to have a records retention policy. In a perfect world, the records retention policy would also be a records destruction policy, because if your policy says we keep this type of record for 7 years, at the end of the 7 years, it should be destroyed. Not everyone has done that. I know many of our smaller members have any record that ever has been created by their agency. So this is language out of the statutes, and it specifies that public agencies should designate a custodian or custodians to deal with public records requests. So many of our members, cities are probably a good example, may have several. City clerk's going to be a custodian, maybe somebody in the police department, somebody in the fire department, somebody in planning, and certainly somebody in the library. Generally, those shouldn't, because you're the person who has the closest contact with the information and kind of has an idea of what you have and don't have. But it's up to in the case of a city, the city council to designate those persons. So this is the language out of the statute that deals with the fees. And it specifies that the first 2 hours or first 100 pages of records that are requested, and when we're talking about 100 pages, we're talking about those requests that are asking for copies of records, are free, and beyond that you can charge a cost. However, there's some limitations. The statute says you can only charge the actual cost of making the copies, or in the case of labor. And where we run into labor most of the time is where we have a record or a series of records that has some information that's available to the public and some that's not. And someone has to go through and basically redact certain information. In many cases, that has to be your attorney. So it may be someone that's $150 or $200 an hour, and that may be the lowest paid person who can reasonably respond. In other times, it may be just digging through files. And in that case, you charge the wage of the lowest paid person who could do that in a reasonable manner. So let's start off with what is a public record. If I were to ask most of your patrons, they probably would say, well, a public record is something you have that I get to see. And they would be pretty much wrong. A public record is a very broad definition. It includes anything relating to the conduct or administration of the public agency's business. However, it's only a writing under this section of the statute. However, 3 paragraphs later, writing is defined as pretty much everything. So the only information about your library, about your public agency that is not a public record is pretty much what you have between your ears. And so it's a very, very broad definition. And again, expanded with the way we communicate electronically in today's world, even though it's not specific here. It's other methods of communicating that may not have been anticipated when this definition was written. So this is kind of off the topic, maybe a little bit, but my guess is that most of you, let me rephrase that, all of you I know have a personnel policy. Our hope is that your policy provides some guidance on employee conduct. This is language out of our sample policy, and it specifies that employees who work for a public agency are not authorized to release the public record unless they're the official that's responsible. So this is an important training thing for all of you. All of your staff should understand that unless they're the designated person or one of the designated persons, they should not be releasing public records. We run into problems with this periodically where someone says, well, I'm a public employee. I've been here 2 weeks. I know where things are hidden. My friends would like to see this, and they just take it for them. That's not okay. Release of public records without authority should be a discipline issue. So it requires some training because it's often misunderstood. So one of the challenges with dealing with public records is how do we capture them? So some of you have received some public records requests that includes things like emails sent by your staff or by your governing board members that may or may not have been sent on a library hosted email site. And so another thing we deal with is text messages. I run into fewer and fewer public agency employees who have two cell phones. So it's common for us to use our personal cell phones to do work with. I know that I do. So if I get a text message from one of you saying, I have this issue, can you give me a call? Technically, that's a public record because it deals with my work within ICRMP. And by the way, ICRMP is a public agency, so we have to comply with these issues as well. Another thing is not everything we get, well, let me rephrase that. A lot of what we get has nothing to do with our agencies. We all go through our email first thing in the morning, and my guess is that we spend the first 10 minutes just deleting all the stuff that is junk or scam emails, other things. When we do that, we have to be a little bit careful about, is this really something that should be thrown out? And there should be some guidelines on that. The other thing about electronic records is I may delete it from my cell phone or from my computer, but there are gurus around with IT training that can bring it back. And so nothing is ever gone. So the best advice that I can give you is keep your words sweet in anything you write or say ever, so that if you have to eat them, it's not too tough. And you need to have policies, and then you need to have training for all of your employees so that they recognize when to create and when not to create public records, and what type of things they could do inadvertently that could create a public record. I'm thinking of photos. My guess is that many of you in your libraries have employees who are young, maybe volunteers that are in high school, and all of them carry a cell phone. And they all know how to take photos really quickly. And so let's assume that your library is visited by some famous person. So what do your employees want to do? I'd like to get a selfie with that famous person. Not thinking that when they do that, they just created a public record. And if it's released to their friends, which is what they want to do, now they have created a public record and released a public record that, depending on where it's at and what all is in that email may, or that text message that they send out, may actually provide information that shall not be released, because it can give an indication of who was in the library and what they were doing. And as library staff, you all understand that's forbidden. So let's talk about the response to public records. As a public agency, you always have a right to request any public records request be in writing. My recommendation is don't do that. It just makes your life too complicated. If someone comes in and talks to you and says, you know, I'd like to see a copy of the agenda or a copy of the minutes of the last meeting, you can say to them, we need you to have that put in writing so they can go away, find a form, bring it in, then you can process that and give them, and then give them the minutes or the agendas. Or you can just hand it to them in, 10 seconds and be done with it. Don't make your life more complicated than it needs to be. However, that needs to be limited to rather simple public records requests that you know the answer to. If it's not simple, then have them fill out your form. And so we actually have a sample form on our website. If you need to find that, you go to ICRMP.org, our website, and you all know how to get there. You go to your favorites, and then ICRMP.org is one of those favorites, right? Well, if it isn't, it should be. And then on the top, there's a list of options, and you go to the Contact Us one, and on that Contact Us page, there is a sample website that you can use, or a sample form that you can use on our website. this is kind of what it looks like. So you may want to, actually you should review this with your attorney before you use it. And you may need to do some changing. It has several things that are important. It gives the specific statutes. It allows individuals to ask for or to let you know how they want to see the records. Do they want to look at them? Do they want just the records that pertain to themselves? Or do they want copies? Probably that should be 2 lines. Do we want hard copies or do we want electronic copies? More and more of the requests that we're seeing are actually asking for only electronic records, because then there's probably not a cost. They need to print their name, provide their address, a signature. The signature is important because as custodians of public records, you're required to give out all kinds of records. You're also required to make sure that they're not going to be used for a mailing list or telephone list. Well, good luck with that. So the best you can do is get the requester signature acknowledging that they're not going to use them for that purpose. I can't think of any library records that would be allowed to be used for mailing or telephone lists. There are some records, however, that can be. For instance, the list of registered voters that your county clerks have, those can legally be used for mailing and telephone lists. Most other records cannot. And I can't think of, again, of a single one that a library would have or might even have that would fit that definition. Again, you may have your own forms. And if you're going to use ours, please have your attorney review it, make sure that it meets your needs. So once you get a public records request, you have a fairly short time frame. Under the statute, you have 3 days to respond, and you're required to notify the requester in writing within 3 days. I sometimes get questions, well, does that 3 days include the weekend? Probably not. I'm thinking it's probably 3 work days. And you can do one of 3 things. You can say, yes, here are the records. You can say, yes, you can have the records, but your request is so large that fees will apply and you need to send us $200 before we will complete it. Or you can say, yes, we have the records, but it's going to take us up to an additional week, so up to 10 days to provide those records. Or you can deny the record. If you deny the record or part of the record, you need to include that you contacted your agency attorney and they told you to do that. You also then need to provide how they can appeal your decision to deny part of the records or all of the records, and what the appeal period will be. So denying a record, and you need to deny records because there's a lot of records that you should not give out. However, when you deny them, you need to be careful. So this is just a chapter out of the actual statute. Normally, I don't try to put this many words on one slide, but this has something in it that you don't often see. For some of you, this is a statutorial required lie. So if you deny a record, you are required to either consult with your agency attorney or put in writing, I had the opportunity to consult with my attorney and chose not to. My suggestion is you should never, ever do that. So what that means is that every public agency, regardless of the side, needs to have an attorney. If you can't afford an attorney, you probably can't afford a book. We have a saying at ICRMP, the only thing more expensive than your attorney is not using your attorney. Nowhere is that truer than when it comes to issues like public records, open meetings, conflict of interest. So this is in the statute. The statute number is there in case you want to look at it and show your governing board that you need to have ready access to an agency attorney. It's important to recognize the public agency or your public agency as attorney. I have run into individuals who said, well, I have a private attorney, I'll just ask them. That will not provide the protection to you that your public agency attorney will. So this should be the agency attorney. So I said earlier that the definition of a public record is very, very broad. But all of those public records are not necessarily available to the public. In fact, they're now page after page. On the copy of the statute that I looked at, there were 19 pages of records that are not necessarily available to the public. Most of those records start off with the paragraph, the following records need not be disclosed. But there are some cases where it says shall not. Two of those are on this page. The records of a library, and you all know this, that would reveal the identity of who used this book, what they're looking at, anything about your patrons that identifies the individual patron is pretty much shall not disclose. And there are exceptions to that. You know, if it's a court order, then you need to do that. But short of that, you need to not allow those records to be released. And again, all of your employees need to be trained about that issue because they don't always understand that. The second one is personnel. So there's certain things about your employees or volunteers. And when I say personnel, I'm using a broad term that includes elected, appointed, employed, or volunteers for a public agency. And so this is language, again, directly out of the statute. So the name of your employees and your board, their employment history, how long they've been there, wages, including bonuses, severance packages, even things like the amount of expenses that they're reimbursed for when they travel to the library conferences or other trainings, their pay grade, gross salary. Gross salary is important because there's a difference between gross salary and net. And the difference is how many things are taken out of it. So, you know, if you look at my gross salary, well, mine would be a bad example, but if you look at gross salary of some of your employees, there may be, depending on your policy, more or less taken out based on how large the family is that they have that's on your health insurance, for example. So there's lots of information there that should not be. It's a gross salary only, not the total amount or not the withholdings. So those are available to the public. And then it goes on to say all other information shall not be released. So things like the employee's application, their evaluations, their complaints made against them, their requests for benefits like family medical leave, the records that show the injuries that they had that was covered by workers' comp. All of those things shall not be released. And so it's important, again, for the custodian to understand those differences. Probably the most common question that I get here at ICRMP about it is someone wants to know how much my employees make. Do I have to let them know? The answer is yes, in whatever detail they want. Sometimes you can provide, here's our salary range, and based on you know, how long they've been here and what their job is, they fit somewhere within this range, and that's okay. Other times they want great detail. So they're entitled to how much each employee makes by name. You may be able to avoid that by just saying, here's how much this level employee makes within our organization. When you do that, be careful not to give out too much information about anything other than the gross salary. So the statute specifies that requests may be required to be in writing. That doesn't always mean that they have to fill out your form, though in many cases that's the best option. And part of the reason why I recommend that is, again, you want the signature that's saying, we understand we can't use this information for mailing a telephone list. So the requests don't have to come from your patrons. They can come from anybody, anywhere. I added countries, I just made that up. That's probably not true, but Oftentimes, some of the public records requests that we see frequently now are from organizations that are trying to put together metadata that they can then use for whatever purpose. And the reality is it doesn't matter what that purpose is. One of the ways to get in big trouble is to ask why someone wants the records. Just don't go there. Now, sometimes you may want to coach them a little bit, but you have to be careful about how you do that. This should be someone that is either experienced in doing this or involve your agency attorney. But if you get a really large request and you know that it's going to cost somebody some money to do that, even though your per copy charge is limited, probably 5 cents or 10 cents. If it's more than that, you got to review that with your attorney. But so someone requests something, let's say they wanted to know, I'm struggling with an example, but they wanted to know how many people use your library. Well, that's kind of a generic question. If you look at individual records, that's going to be a lot. And when really what they want to know is how many people came to this program. Well, you may be able to answer that question. You don't want to give the names of who came to that program, which brings up another point. Sometimes individuals ask for information that you don't have. Like, you don't have a list of how many people attended. You have a list, but it has their names on it. Sometimes it's better just to give them the information, even if you have to create it. You don't always want to do that, but oftentimes some of the requests are asking for records, again, that you have, but there may be things on there that you're required to redact. So maybe instead of doing that, maybe you can provide the information they want by doing a short query from your your IT department may be able to put together something that provides the information they want without releasing the information that they can't have, without having the cost of someone go through and redact hundreds of pages in some cases. I've already covered this, but it's an important thing. It's probably the most important thing that you will hear from me today, so it will be repeated more than once. If you deny a record or part of a record, there's a good faith denial of a record, and that means you consulted with your agency attorney and followed their advice. A bad faith denial is that you did not consult with your attorney. And if you go back in the statute, in the public records statutes, there's a monetary fine. It's not exactly like a fine, but it's a cost for those who deny a record in bad faith. And that cost is not going to be to the library, it's going to be to the individual person who denied that request. So you don't want to go there. You need to have access to your attorney. Just in the for what it's worth category, if you have a fee and someone makes a large request where there's going to be fees imposed, before you go to the work of putting together all the records, collect the fee first. I've had some experience with that in the past where we had major requests and then discovered that, once the work was done, they didn't want it. I know this would never happen in your communities, but we have people who are making public records requests just to make it difficult on public agencies. And by the way, that's kind of a right. So this is kind of getting to the issue of what's the difference between a public record and a record that's available to the public. So this is kind of a test question. And because I can't hear your answers, I will give the answer. It's the kind of open book test we all wish we'd have gotten in high school. So for each of these types of records, there are two questions. First is it a public record? And then second, is it available to the public? So recordings of the city council or your trustee board meetings, is that a public record? If you record it, yes, it's a public record. Is it available to the public? Yes. And by the way, this is one of those things that you have to be careful about and should be addressed in your records retention policy. I know many public agencies that record their meetings say we'll keep the meeting recording until after we've approved the minutes and then we'll destroy it. If that's what your policy says, that's probably okay. If it's a city, that's a really bad policy because you need to keep them longer than that. But for others, you may be able to do that. It's important to recognize, and I run into this a lot, haven't heard it since last night in a class that I did, where there's a common perception that minutes of the meeting are not available to the public until after they're approved by the governing board at the next meeting. That is not true. You should make sure that within 3 days after your meetings of your public agencies, whatever that is, that the minutes are available, because they are available to the public, and there's nothing that's probably more public than that. If you question that, there's a little court case out of Boundary County. It's one of those few court cases. It was Idaho Supreme Court case where I knew both of the individuals, so I can understand why there would be a conflict. But basically, the Supreme Court said in relation to a records request to a county clerk from a citizen that said, I'd like to see the minutes of the last meeting. And the clerk said, well, they're not I haven't drafted them up yet. The only thing I have is my notes that I took in the meeting. And ultimately, the Supreme Court said, if that's all you have, then those notes are available to the public and you should be able to get them in 3 days because they're readily available. So my suggestion is make sure that you have, whoever does the minutes should be able to make that transfer from their notes to draft minutes. Now, if someone requests them, it's important that these are not the final minutes because they're not approved. So you should have a stamp that says draft minutes on them, and then give them out, whoever requests them. Books in your library collection, public records? The correct answer is probably no, because remember, the definition of a public record is something dealing with the conduct or administration of your public agency. So the books are available to the public, that's why you have them. And by the way, if someone requests a copy of a book, you know the answer to this. I've actually, in my past life, we had a citizen, I should explain my past life, I'm a recovering county commissioner, but we had a citizen who requested a copy of each page of a book because it was a $300 book and it was about 300 pages. And so we charged 10 cents a page. Well, that's $30 if my math is right. She said, well, I can afford $30, so I want a copy of every page in that book. Of course, that was denied because that's a copyrighted material. You can't do that. Names and home addresses of employees and elected officials. Is that a public record? Yes, because you use it as part of your conducting your business. Is it available to the public? This is one of those where the statute specifically says shall not be released. So you shouldn't be giving out home addresses of even your elected officials, even though everybody may know where they live. You shouldn't be giving out their addresses unless you have their written permission. Wages and salaries of all of us, employees and elected officials. Yes, those are public records and available to the public. Information in my personnel file, is it a public record? Yes, because it's used to conduct business. Is it available to the public? No, it is not unless I give written permission. And so often I'll have employees say, well, why would anyone give written permission? The answer is often they're looking for a new job. Many employers, prospective employers, including many public agencies, as part of the application process, will say, we need you to authorize us to get a copy of your personnel file from your previous employer. So if you get that, then yeah, you can release that. The next one's more complicated. Records of calls, texts on your personal phone. Well, not everything that's on my personal phone and who I've called is a public record. However, those calls that I did related to work would be public record, and whether or not they're available to the public depends on the content. So it's not whether or not it's a call or a text. So let me give you an example. I get calls on a regular basis from our members that are asking for assistance, as does my coworkers Carl and Tammy, asking for assistance to deal with an employee issue. So when I get that email, Sometimes it may contain information about who the employee is and what the problems are. That's a public record, but it is not available to the public. Other times, frequently, if I'm out on the road and I get a call that I can check on our email system. So if you call ICRMP and leave me a voice message, it's actually converted. It's part of our email system. So there's a record of that. So that's a public record. Whether or not it's available to the public, again, depends on how much information you put in. If you just say, I'd like you to call me, please, that's probably available to the public. I don't think anyone's going to ask for it, but it's technically available. On the other hand, if you say, I'd like you to give me a call because our employee, John Doe, just did this and I want to talk to you about it, that's information about a personnel issue that would not be available to the public. So just be careful about assuming that what you have is all available or all not available. The answer is it depends. And that's not a clear answer sometimes. So that's kind of the extent of what I have in the presentation. Again, this will be available to you. So this is my contact information here at ICRMP. I'd like to take the photo off, but I was told I couldn't. So with that, I would be glad to respond to questions, comments, whatever you see.
Great. Yeah, folks, as you have questions, please type them into the chat and I will read them out for you. We already have one. So where can we find legal requirements for retention of various types of records?
So that's a trick question. So firstly, it depends on what type of agency you are, because there are some guidance. But for most of the records that libraries would have, the correct answer is whatever your governing board has established as a records retention policy. And again, that was supposed to have been done several years ago. So if you don't have a records retention policy, you're kind of lost. So what I would recommend is put that on the next agenda of your governing board. If you don't have one and you want to start from, you need to start from scratch, then I would look to other agencies similar size and see if you can borrow theirs as a starting point. And then you should never take somebody else's and just adopt it. But the correct answer to how long you keep something is how long your policy establishes. Now, there are certain things that are kept forever. The documents that created your organization, the minutes of your meetings, those are forever records. But short of that, you should look to your policy. And your policy should identify that these are permanent records to be kept forever.
Okay, next question. With personal phone conversations, how do you get a transcript of what was said, not a text or recorded message, but an audio conversation, if they are indeed public records and available to the public? So
they're not a public record. If you talk to me on the phone or on the street or come talk to me personally and we're not recording it, there's no record. So it's not a public record if it's not a record. So often, and I have some of our members that I talk to frequently make fun of me for this. So I'll get an email from a member with a question and they expect an email answer. No, I'm going to call them on the phone and talk to them. Because firstly, if I'm going to send an answer, I want to make sure that I understand the question, and there's usually more to it. But yeah, phone conversations that are not recorded, you're not required to record conversations. And so they're not a record because there's no record. What may be a record, and I've actually seen this disclosed in a court case, was actually a criminal court case where the detective had called some of the witnesses on his personal phone. And so there was no recording of that conversation, but what was available to the other side was when he had called them and how long the conversation lasted, because that was on his phone history. But the actual words, not a record, no requirement to keep it.
Say there was a recording of the conversation, does that then become a public record?
If the public agency has a recording of a conversation, yes, just as if you call me and leave a public record on our on our email site, that's a public record. And it'll be there for, unless I move it to a file somewhere, it's there for 30 days and then it goes away, because that's under our records retention policy. Our emails last for 30 days unless there's something important that we move to a file. And we have a system for doing that.
Okay, next question. Should we redact names of people receiving messages like emails sent from a public agency if the recipient is also a staff member at a public agency?
So there's two answers. First is it depends. So it isn't how you send them, it's what the content is that determines what's available and what is not. If you're going to redact, or you think you should redact, the correct answer is whatever your attorney says. Because for the most part, you send me an email, the fact that you sent it is going to be a public record. And unless there's some specific reason that it wouldn't be released, it would be available to the public to find out who sent me those emails.
Okay, next question.
Okay, go ahead.
Are there any guidelines for retrieving records from personal devices?
Yes. That is, first of all, ask. So if it's a trustee, you may want to ask politely. In some cases, it needs to be a third party that does that. So if someone requests to see all the text messages that I sent to one of our members about this issue, and by the way, I wouldn't do that, but if I did, then, and there was a public records request for that, usually that would be a court order thing, but even if it wasn't. So the answer to that is somebody's going to go through my emails or my text messages and determine which ones dealt with that issue, and it's not going to be me. So I remember Jerry Mason, who was a city attorney for many of our members in the North for a lot of years, described one of the earlier public records requests that the city, one of the cities that he represented, received. And it was for that exact thing. I want to see the information that's on your phone about this issue. And he said he was tasked with going through that person's private text messages regarding all kinds of things to sort out the ones that were about this issue. His description was he felt like he was going through somebody's underwear drawer. It's not comfortable. In a perfect world, you would have a policy that says any messages that you send or receive would be sent to, some kind of repository that's maintained by the library, so that you could easily say, every time I get an email from anybody, I forward it to myself at my library email, and hopefully everybody has one. And therefore, you don't need to look through my personal stuff. Now, if it's in litigation, the opposing attorney is not going to believe you, but the court will say, we're going to look through it. And so they go back and look at the last half dozen emails that you received related to work, and they look at your work email and they're all been forwarded there. That's probably going to be the end of it. That's the best example that I can use, is forward any emails or other information that you receive, make sure that resides on a library server or city or school district, wherever you work.
It sounds like the advice that's beneath what you just said is to not use your personal devices for work stuff.
That's not necessarily true. I mean,
okay.
In today's world, I use a really bad example, but most of us don't want to carry two phones, and we use it interchangeably. I don't think it's a problem to use your personal phone. Now, if you're involved in some serious criminal activity that you conduct on your phone, then I wouldn't do that. But for most of us, it is that big of an issue. And the likelihood for most of us to have that requested is probably pretty limited. Again, major conversations should be in some form that's capturable. If governing board members are receiving information, say about the upcoming meeting, that should be in an email that's easily captured and recorded so that everybody knows it, and it can be made available to the public if necessary. But just for day-to-day business, can you give me a call? When are you available to go lunch? I don't see a problem with that on personal devices. So here's the inappropriate thing that I normally say when asked this question. In today's world, I think having a cell phone and coming to work with a cell phone is kind of like coming to work with clothes. It's just expected. Okay, it's not, that's a really bad example, but if your agency wants to have work phones, there's nothing wrong with that. It's just really awkward. And my experience is those who have work phones still occasionally conduct work on their private phones just because it's convenient. That was the case of the example I used with the officer in the criminal case. He had a work phone. Most of his calls were on there, but a couple times he was hard to reach, and some of the witnesses were hard to reach, and so he called them on his personal phone just out of convenience. That's the way most of us live our lives, even if we have a work phone.
Mm-hmm. So next question, for text messages on a personal device, is an employee required to hand over their personal device for this purpose, like for checking through the messages, or would it be up to the phone company to retrieve those messages?
Probably not the phone company. So there's not a clear answer to that. It's going to depend on what's being requested and where it's there. Most of the time, that's probably information that's going to be only released in litigation, and then it will be part of discovery. So you'll have attorneys looking at it and sorting through it. But it could be a public records request. And if you're doing that, again, that would be probably someone other than, it's not going to be the person who requested to see it. It's not going to be the person whose phone it is. It may be, again, probably the best person to do that or to guide that review would be your agency attorney.
Nice. So any other questions for Jim before we thank him for his time and allow him to go off into his afternoon? This has been a lot of really good, meaty information, and I'm glad we've had this webinar.
Of the things that I talk about and provide training on, records are probably my least favorite.
Sorry.
There's not a good answer to a lot of things.
A lot of it depends.
It depends, yes. And consult your attorney. Yeah. No others?
Nope, not seeing any others.
Okay. Well, thank you for this opportunity. This is a fun way to reach a lot of people. So there are probably 3 or 4 listening, huh?
Well, we had 28 total, I believe, listening. So you reached a good audience, and this is being recorded. So another 25 or so are going to see it as well.
All right.
And if folks have questions, they have your email address and your phone number right there, which is perfect. So thank you so much, Jim, for joining us. This has been super informative. I'm going to end the recording now.